One sec. And we're live.
Okay, good evening, one and all. This is Glenn Richards, Chair of the Newburyport Historical Commission, opening the meeting for Thursday, the 23rd of July, 2020, a virtual meeting conducted via Zoom, as most of our meetings are these days. So I'll begin as usual with a roll call so we can see which commissioners are here. There's myself, again, Glenn Richards. Christopher Fay, are you with us? Okay, I see you came off mute, but I'm not hearing anything, Chris. I'll give you a minute to check that out while I go through others. Patricia Pecknick.
Yes.
Okay, Peter McNamee.
Yes.
Okay, Mr. Joe Morgan.
Yes.
Mr. Ron Ziamba.
Yes.
Okay, and did Malcolm show up on anywhere in the attendees? Oh yeah, I see Malcolm there. Oh, he just
did. I
disappeared.
just promoted him to a panelist, so hopefully
Oh, great.
he can say hello.
Okay, so Malcolm, I'm not sure if you can speak or not, but Malcolm Carnwath is joining us actually.
Oddly, it looks like he oh, there he is. Okay, he's back again.
Okay, there he is. Oh, good. Okay, and Christopher Fay, did you get your audio situation straightened out?
I see his hand is raised. It looks like you're muted on your, or not muted on your end, but maybe something is not working right because we can't hear you.
Okay, well, we know Christopher Fay is in the meeting. At least he can hear, and because apparently he's heard us addressing him, so we're gonna consider that he is at least present. So anyway, let's move along. There's a fairly light agenda tonight. If anyone else is in the attendees list, and I'm not seeing anyone at the moment, but if anyone, well, so maybe I should save my breath, but anyway, they're muted until they raise their hand and identify themselves and so on. The first item is the withdrawal of the application for 3-5 School Street. Now, I'm not seeing anyone here to represent them, and I'm hearing something.
It might be a little bit of feedback from Ron's microphone, I think it looks like to me. That can be done just by muting whenever anyone's not speaking. Attorney Mead had submitted the request for withdrawal. I think that's what we have that in writing essentially. So the applicant is not required to be here, and we didn't have any reason to. Typically, we just recommend granting the withdrawal without prejudice.
Yep. Okay, so that sounds like it requires a vote of the commission. So just to be clear, I'll go ahead and make the motion myself. The motion is to accept the withdrawal of the application from Redco Construction, care of Lisa Mead, Tellerman, and Costa for the application pertaining to 3-5 School Street. They have changed their plans and no longer require, a hearing or permit or anything else, and they have requested to withdraw the application. The motion is to allow this the application to be withdrawn without prejudice. Is there a second? I do need a second from somebody.
Second.
Okay, thank you. That sounded like either Peter or Joe.
Yes, Peter.
Okay, thanks, Peter. Okay, so I'll go around as long as you've got the mic on. Peter, your vote?
Yes.
Okay, Patricia?
Yes.
Okay, Ron, I think you're unmuted. Your vote?
Yes.
Okay. Christopher Fay, maybe you can raise your hand to indicate a yes or something if we can't hear you. And while waiting for that, he raised his hand. That's good. Joe Morgan?
Yes.
Okay. And I'll vote a yes. And Malcolm, let's see, you're unmuted.
I'm here.
Oh, you're there. Great. Your vote on this, Malcolm?
I agree.
Okay, that's a yes. So it sounds like we are unanimous in that. No, 1, 2, 3. Did I miss anybody? I think I got everybody right. 1, 2, 3, 4, 5, 6. I should have 7. 1, 2, 3, 4, 5, 6. Oh, I left it. Who did I miss? Peter, Patricia, Ron, Malcolm, Joe.
Yourself, maybe?
I don't know. I think I got everybody. Oh, Chris. Okay. Okay, so that is unanimously passed. Thank you, everyone. The next item on the business, on the order of business, falls under the category of general business. There's been a number of preservation restrictions that we've had to deal with of late, and a lot of questions have arisen about them. So, and I know Andy has been looking at ways to improve the way in which we handle them, make things a bit easier for both us and the applicants, make things go a little bit more quickly, smoothly, etc. So without further ado, why don't I hand it over to you, Andy, and you can share with us your plans and ideas.
Okay, thanks, Chair. Let me just, hopefully everybody can see this preservation restriction I have on the screen here. I was just going to walk through a couple of things. This is basically what I thought was important to go through because commission members change over time, and I think we've all been trying to improve our processes and tighten up our procedures to make sure that, well, speaking for myself anyway, that developers and their representatives cannot inadvertently take advantage of loopholes or our lack of understanding of how things should be done. So I think it's good for us to have basically institutional knowledge amongst the commission members about what a preservation restriction should look like and what it should have. I know there's been a recent discussion of other preservation restrictions and whether or not language was adequate and the provisions were appropriate. So although there's always details to look at, there are two things I thought were worth noting. One was to look through true preservation restrictions tonight, just highlighting a few things in the document that are worth being aware of and things that you should look for as members in the future when you're reviewing a PR. The other one was just the suggestion, I think a discussion that Chair Richards and Vice Chair Pecknick, we've been discussing with Caitlin, putting on a Word version of a appropriate template for a preservation restriction on the website to make it easier, because we found that some people who are working on it on their own without an attorney, for instance, they may get confused, or they may take them a little bit longer to figure out what to do. And they may use a template or a document that's older or inappropriate. So we thought it would be appropriate for us to get ahead of that curve and try to give people a version that makes sense, and one that meets MHC standards and would meet the commission standards. So what we're looking at tonight is a preservation restriction that is for the high school and one that is for the old or former Kelly School building on High Street. And I just wanted to highlight a few things in here, but I did reach out to Michael Steinitz again today and ask if he could confirm or provide to us a most recent Word version of a template that works for MHC. They do periodically update some of their boilerplate language. They're usually pretty standard. But given that this stuff happens all the time, we thought we'd speed up the process, because unfortunately these PRs take quite a while to get routed for review and approval and so forth. And so because of the amount of time it takes to do that, we're trying to reduce inefficiencies so we can stay ahead of everything. So if it's all right with you, without further ado, Chair, I'll go through the document.
Mm-hmm. Yeah, quick question, Andy. You said you reached out to Michael Steinitz. Did you speak to him? Do you have any kind of well, relationship may be too strong of a word, but are you in contact with him on any kind of a regular basis at all?
No, not on a frequent basis. I mean, I certainly probably could be, but it just, given the other responsibilities I have, it's only periodically that I reach out to him. I know he's probably got a lot of work on his plate, so it's hard for him to keep up with everything, sure, as with me. But he has been responsive, I think, when he has the time. So I will check in with him again, but I don't speak with him on a frequent basis.
Okay, just wondering. Carry on.
Okay, so, and feel free, all members, to just interrupt me if there's any questions along the way. So this is go ahead.
I'm sorry. Yeah, I just wanted to point out so that everyone, especially the new folks, understand. You'll notice that this preservation restriction is between the city of Newburyport and the Historical Society of Old Newbury. And I'm sure, Andy, you'll probably cover this, that usually the ones we've looked at, we, the Historical Commission, and the city hold, we're the grantee. In this case, it's a city-owned property, and the city can't hold its own restriction. Is that something you were going to talk about? So I just wanted to point that out right at the very top so people understand how that's different in the case of a city-owned property.
Yes, thank you, Chair. That's actually a great point. I was going to hit on that, but I'm glad you hit that right off the bat. So yeah, the The first thing to notice about this one, and it's different than the next one I'm going to show you, is that this one is the city of Newburyport as the grantor, because the city of Newburyport is the one granting as the owner of the high school building to the Historical Society of Old Newbury. And that's because essentially we can't, the city, give it to our own historical commission because it violates essentially the legal doctrine of merger, where essentially the law logically concludes, and the case law logically comes to a finding that the city can't really hold itself responsible. It's not really proper for it to claim that it's going to hold itself responsible because it's sort of a loop, it's sort of a cycle.
Yeah.
So at any rate, in this instance, we give it to another entity that is qualified to do so. In this case, the Historical Society of Old Newbury agreed to accept the restriction. I think the mayor had reached out to them. And so, as the chair pointed out, this one is the city granting it to the Historical Society of Old Newbury, which effectively, as with the Historical Commission with other restrictions, acts as the policing entity and the one that monitors to make sure the city doesn't violate this preservation restriction. So if there are, the other one I was going to show you actually is for the Kelly School. And if, for those of you obviously who I think know the history there, because that building was previously a city building, and the developer, Diamond Corey, ended up purchasing it from the city and redeveloping it as housing. They were, as the new owners, granting the city the restriction so that the city could enforce a restriction, making sure that the Kelly School stays in accordance with the preservation restriction, which I'll refer to after this one. So one thing to notice about this restriction is this is the truly recorded one at the Registry of Deeds. So it has the barcode and the stamp of the the date that it was recorded, the time, and the book and page number, so that folks can find it. I don't think that the Registry of Deeds is the best way to track land information, given now that we have mapping systems, but we've had that historically, and that's the way that things are tracked. So as most of you know, we sort of look for property information by going back in time and going from book and page to find information on a particular property. So this is the book and page of the registry, and we try to keep track of all these PRs. We are working to have them not only available from the city's website, which I know Diane has been good at trying to post those to the Historic Commission page, but also we're trying to get into our permit tracking software that we're working on right now with a vendor, so that the commission and members of the public can see all the restrictions that are out there in the city and can see what the terms are, and basically look at a PDF like this for any particular property that has one. I noticed that Ron may have had some difficulty connecting. I don't know if he wants to re-announce his arrival or if he's able when he's able. So in this preservation restriction here, the first thing I wanted to note was this first paragraph here. It says the date the restriction is signed, but it says basically the parties to the agreement, and this is the difference between the grantor and the grantee. I think that was a term that came up. There was an error in the typo. It was a typo in one of them before, but that is important. The discrepancy that was noted in the last one we looked at, because it used the word grantor in place of the word grantee or vice versa, it might be a provision that then doesn't allow the Historic Commission to enforce something properly. So it might seem counterintuitive, but the legal language does matter. So anyway, this just outlines the fact that the grantor and the grantee are such and such parties, and then what their locations are address-wise formally, as you would with any deed. The next paragraph, this is just deed references at the Registry of Deeds. And again, members, jump in if you have any questions or comments anytime. This next paragraph is really just a lengthy description of the building or structure involved. And I'm happy to pause on any portion of this, but I just wanted to highlight again the important features that you should expect to see in a PR. This is a lengthy section, so there's more description of the building.
Yeah, I would just mention the other, and one of the reasons it is lengthy, Andy, is, and if you look through some of this, you'll see that they call out specific things that they consider of particular historical importance. That mentions the weather vane, and this, things that might not ordinarily require calling out if something that has some historical interest for some reason. The columns, the particular, any historical features that, especially if they are things that are there's a particular interest in preserving. Yeah.
So this paragraph I thought was worth noting. These two together, these are basically exclusions. So you'll see here, this one is the example. It says 2001 addition and the stadium behind the addition are not covered by this preservation restriction. So again, this is, language worth looking for if a developer, and you're, again, I put the developer as an example because they may sometimes be on the opposite end of the spectrum from where the city wants to be on an issue. So the point here is to look at the language, closely and make sure that the whole building that, or a portion of the building that you think needs to be covered is covered, and that they haven't exempted something inappropriately, based on the historic relevance of that building, which is your area of expertise.
Yeah, that's interesting that in this case, even though it's kind of part of the building, that Mass Historic, was accepted this exemption, so to speak, maybe because it was so recent and all. Any comment on that, because how with the Central Church there was a problem with, they said the preservation restriction has to include the entire building, but in their case even the so-called newer part was still quite old, so maybe that was the difference.
Yeah, I don't actually know the exact dates off the top of my head, but you're right. Mass Historical obviously did not feel that presumably, reviewing this, did not feel that the more recent addition was needed to be protected in order for this PR to be satisfactory for that structure.
Yeah, it probably was the age.
Then there's a reference here. The building is further described as shown in Exhibit B. And so there are exhibit drawings that are referenced for clarity, because you can have a lengthy description of all these items in the building, but it's much easier if you have a set of drawings to make sure that people know where things are, and what the dimension should be or proportion should be of something. So plans are much more helpful than paragraphs if possible.
Now you're saying plans, they typically, usually I see photographs, Andy, so do you often see PRs with actual plans, like architectural plans, or is it usually just photos?
Yeah, sure. So, and I'm not the expert per se in preservation restrictions, but I've seen both examples.
Okay.
If possible, it's always better to have both. I've seen both, frankly, and with the Kelly School one I was going to show you in a minute, there's also plans for work that was proposed to be done that hadn't been done yet, but was being referenced in the PR, and I will explain that. Yeah, I've seen both. It's preferable, if possible, to have drawings and photographs, but at least the photographs should be there at a bare minimum. Then we have this sort of whereas clause. This gives the background, basic clauses about the history and the significance and purpose of the PR to protect certain, relevance of the structure involved. I won't go at length with that, but that's what that section really is about. There's a lot of whereas clauses in here, basically setting up for, basically explaining why there's a preservation restriction that's being assigned here. And then there's the whereas section that makes reference to what is important here, which is that baseline documentation. So this is where Chair Richards pointed out the photographs. So this is a listing of all the photographs that are actually in an Exhibit B at the end of the document. I will note as we get to the end of the PDF here that the recorded version of these PRs is not always as legible as the original version. So while it's nice that they're in there and even the plans are in there, unfortunately, what seems to be legible is still problematic, in my opinion. If you're looking to enforce, it's always good to go back to the original. Unfortunately, it just doesn't seem to transpose correctly or decent enough with the recording.
Where would the original be, Andy?
Well, I would suggest the city always retain one original copy for itself, so multiple versions executed, if you will. But the original typically stays with the person who's recorded it, the applicant who's been required to record that. So, we try to keep, what I try to do is keep a scanned copy or electronic copy, that's in good quality of whatever documents we get, including something like this. This one I just noticed, I might highlight something later on the document that where one page did not appear to be scanned very well. And so it's a little faint. You can read it, but it's not quite as legible. So these are a bunch of photographs, listed off later in the document with a description of where they are. So maybe it's an addition, it's the south elevation, et cetera. And you've got there's a list of character defining features, and that's one of those Exhibit B attachments, which we'll show later on. There's a assessor's parcel map just showing the building footprint roughly. It's approximation. It's not a survey plan, but it's an approximate sketch of the lot in context with the neighborhood. And then there's some references in here as background. The high school on the city side was getting CPA funds. And so there's a reference to that as part of the reason why there's a PR being developed and recorded for the city's building, even though the city owns it and would presumably want to protect it. This explains one of the reasons why there's a PR actually being put on record at the registry. And this is where we get into really the purpose of this is the grant of the preservation restriction. So it says, now therefore, for good and valuable consideration, the receipt of which is hereby acknowledged, the typical deed language, dry attorney language, the grantor, so this is the city, does hereby irrevocably grant and convey to the grantee, so this is the society, in gross and in perpetuity, this restriction over the property and the exterior of the building to be administered, managed, and enforced by the grantee. So this is the point where typically, as the chair pointed out, the Historic Commission itself is the one that's holding the restrictions on various private properties in the city. There's a few exceptions there, obviously, where the city has a building and needs to grant that restriction to someone else to make sure there's a third-party entity that can enforce it. But in most cases, it would be the Historic Commission that's receiving the restriction and therefore eligible to enforce it by going to court if need be. So the preservation restriction, it goes on to grant to the grantee the right to forbid or limit. So this allows the society in this case to regulate all sorts of things. I won't read through this whole paragraph, but basically substantive types of things, except where they're clearly minor in nature. And we'll get to in a second, there is actually some language in here that speaks to what is minor and what is major. But essentially major things would have to come back to the society for review so they could confirm in their good judgment that it was consistent with historic preservation, including by reference the Secretary's standards. So in this case, if something's minor, the city could go ahead and do it. If there's something that's major categorically, it would have to go back to the society, in this case, the grantee, to make sure that they were comfortable with the work that was being involved from a historic preservation perspective.
Yeah, and many of these, I'm not sure. We'll see if this one has one at the end. A lot of them have an appendix or whatever those, at the end, an addition that a little page or so that this helps flesh out what is a minor, just what's minor and what's not, to help people understand that particular part of the restriction.
Yep. Yeah. And this one does have one, I think, as I recall, it has a good detailed one. I think that's a good example to take a look at when we, get to the end of the document. There's a good exhibit there on that.
Exhibit, that's what I was looking for.
This paragraph here, I thought it was worth just noting this line right here. Where it says the grantor covenants and agrees at all times to maintain. This is beyond just their obligation to keep it in its present, design or state as far as features, to maintain the building in the same structural condition and state of repair. So meaning they don't the city can't allow it to deteriorate, by not providing enough funds to keep it weather tight or so forth. So that's something where you might want to have that language. We've had periodically over the years, sometimes someone will call in and say, such and such a building is not being maintained or kept, weather tight. There are raccoons or squirrels getting in there and, damaging the building. And, you have to keep the building weather tight or, protected from the elements to really keep it in good condition. So that language is in there for that purpose. Then there's the language here to reference to the Secretary's standards. And that is really referenced in there because the entity that's holding the restriction is typically looking back to and should be looking back to the Secretary of Interior standards for the treatment of historic properties with guidelines for preserving, rehabilitating, restoring, and reconstructing historic buildings. Those are the guidelines that the commission or the other entity that's holding the restriction should be going back to when evaluating whether or not work involved is appropriate or not appropriate. So that's consistent with how you deal with most things, so that shouldn't be uncommon, but it's good to reference that clearly in the document. So these are, by the way, again, there's a mass historical, boilerplate language that they expect to see. And so we're trying to basically, like I said, post a Word version of that that's in a good, clean Word version so that someone can very easily modify that for any given property in the city, thereby expediting the number of PRs we can process, administratively as need be, and making sure we're not spending time on a poorly crafted document. But these are all things that you should basically expect to see in the restrictions that you're looking at, most of these components. The preservation restriction then goes on. In this section, it's talking about activities that are prohibited. So clearly the building should not be demolished or removed. You know, there's a reference here to no above ground utility transmission lines, et cetera. And the reason for that obviously is it might detract from the historic quality of what people can see. No additions or outbuildings may be attached without approval of the grantee. Obviously, that's something the commission would want to look at if someone else was proposing to do work, just to make sure it's reasonably compatible or
Yeah.
proportional.
That letter D, that's where the error was on a recent one. It had grantor. So basically they could give themselves permission to put an addition or outbuilding. So we had to change that to approval of the grantee.
Right, exactly. Yeah, so I mean, there's just more sections in here about what's allowed and what's not allowed. The grantor shall not alter the building without express prior permission. Shall not make any changes to the building, and it goes on to list, you know, certain types of things. But basically, as you'll see in a second with the exhibit that Glenn and I were referencing, there's a description of what's major and what would require approval or review, at least an approval by the commission or the grantee. Or something that's minor that can be done essentially as of right and does not need to come in for review and approval because it's deemed so minor to not affect the historic character, you know, significantly. You know, that's similar language to that effect. There's the right to maintain and repair the building strictly according to the Secretary's standards. You know, that's again back to the Secretary's standards.
And that was another one on the where that one we just had was before the board a week or two ago. They had added a sentence to Part B there. This is a section of rights they have, as Andy was saying, things they can do without coming back. And they had, so, you know, it basically says they're going to maintain strictly according to the Secretary's standards, right? All very good. And then at the end, they stuck in a sentence, oh, with the except that we can replace certain windows, you know, with ones that are not the same material and all that. So they, when we objected to that, they agreed to remove that. So this is where that fell in, and that PR we looked at a couple weeks ago.
Yeah, that's the good. I think it's very important to point out because just because there's reference to the Secretary's standards doesn't mean that an attorney hasn't tried to sneak in language that will give them a loophole. So unfortunately, you have to read every word in the document and make sure that it logically makes sense. If you have any hesitation or question, you know, you can bring it to the staff's attention. We can let you know if we think it's an issue or not. But you know, if you think something's in question, there's probably a reason and the language doesn't look quite right, and we might want to take a better look at it. The next section here, this is just the process for reviewing the proposed changes. So without going into it in great detail, you know, it says that the 2 copies of the information, including plans, specifications, and designs need to be submitted and so forth. So there's a process. You know, this is if there's any failure of the grantee, meaning the society in this case, to respond to the review in 45 days, it shall be deemed and constituted as approval. So keep in mind if something's submitted to you for review under a PR and there's a time frame like this and this preservation restriction that's involved, which might follow some of the language, you'd want to respond to it in a timely way. Otherwise, something might be deemed approval. That's something we have with all kinds of permits that we deal with.
Yeah, and I can give an example of this one, Andy, too. That's very recent. At the Cushing House Museum, was it Historic Society of Old Newbury, whatever they're called. Anyway, we hold a preservation restriction on that Cushing House and property, and they have that major work that want to do on the electrical system. Of course, there's also CPC funds involved, but even putting that aside, that work is major enough. Sorry, I bit my headphones right off my head. That work is major enough to require approval, review and approval by the commission of the grantee. So you might recall Susan Edwards came in and she, you know, we had, I know Caitlin and I, you know, she took us on a tour where they, you know, reviewed us with, you know, plans and all this kind of stuff is what the electrician was proposing to do and so forth, so that we could then take a vote to approve it or not. So there's a good example of the action of this particular clause here.
This next section, standards of review. Again, the standards of review in exercising any authority The grantee shall apply the Secretary standards. So again, back to the Secretary standards. That's the good thing is it's sort of a global standard that we can all point back to and say those are the guidelines to look at. This is the typical sort of language, that obviously has to deal with acts of God and so forth. So casualty or damage by destruction. So there's got to be provision for that. It's not a section I'm going to spend time on now because we could debate how far provisions like that should go, but there's one in here that covers how that's dealt with and what the process is for verifying that it's there's nothing that can be done to restore the building and so forth. But you have to deal with unusual situations that may be beyond the control of the owner. There's an insurance clause in this one. Frankly, I've not really had any instances in which I've been involved with this particular provision where we sort of, get proof of the coverage for the insurance for the building and so forth. It may be appropriate to have those provisions in there, but I found for all practical purposes that these things just don't seem to get followed up on in a consistent way or a routine way where we're getting the documentation, the proof, all the time that there's coverage. So it's nice to have, but it may be sort of more ceremonial and practical from what I've seen. There's a section here dealing with written notice. So for legal purposes, with legal contracts, there's usually a clarification of who's the person that should be addressed to for each party. So in this case, it's the school department, the director of facilities is the grantor, and the grantee is the Historical Society of Old Newbury with the address. And each party may change that, but you have to give notice, and that's just for clarity. Everybody has to know where you can communicate with someone. It's a little bit less of an issue in these modern days with email and so forth, but there has to be some kind of formal recognition of the entity and where its place is in geography. And there's a provision here to deal with inspections. So the grantee, in this case, can inspect at reasonable times the property, and the grantor covenants not to withhold unreasonably its consent in determining dates and times for such inspections. So you can't have somebody saying, well, there's really no good time to come in the building. It's understood here that there has to be some kind of, mutually agreeable times that need, an inspection can be done. And then this provision, I think, is important to look for, because if the city is going to spend time on enforcing restriction, and there's all sorts of miscellaneous, litigation or appeal issues that come up in a given year, some of the major, some of the minor, and unfortunately, attorneys cost money, and that takes time and money and your tax dollars. So the idea here is this provision basically says that if there's a violation of the preservation restriction, the person who's violating that restriction would have to pay for all the costs that you, in this case, if you're holding restriction as a commission, if they're violating the PR, they could be held liable for all the attorney's fees and engineering fees or whatnot that might be involved. So this is an important provision, I think, to have, because the city and its taxpayers should not be spending money to ensure these preservation restrictions are recorded if it's the owner's, fault that something was done to the building. So, they should be held liable for any expenses that the taxpayers would have to upfront for legal services to go to court and defend the PR. So I'd always expect you to want and to see that language in there. If you don't see it, I would suggest looking for it. And obviously we'll try to keep an eye on the same things, but this is, I think, a good one to have, because it makes sure that in the least, we're not paying for something that is someone else's fault in the first place. Notice of proposed sale. This is just a provision basically clarifying that if the property is sold, there should be notice given just to clarify and make sure there's continuity. The restriction runs with the land, so it's not running with the owner. And if the owner sells the property, it goes away. It runs with the land, and the idea is it's in perpetuity. For restrictions to be perpetual, they have to be approved by Mass Historical. So that's a per state law. So that's why we want them to be reviewed and approved by Mass Historical, because they then can be perpetual. I would note several years back, I don't remember what project it was or how long ago, but I remember there was one project in which Attorney Mead had tried to convince me and maybe the commission of alternative language to argue that the PR would be perpetual. The argument there was, we'll put a paragraph in the preservation restriction that says, even though it's not been reviewed and approved by Mass Historical, the parties both agree that the idea here is it will be perpetual, and both parties will agree to, take actions as necessary to re-record it or whatnot. I do not, attorneys will, put forward what's in their client's best interest, but it's not the type of provision that I would advocate for. It takes, it's sort of a leap in legalistic language to try to defend a provision like that. Unfortunately, the state law seems pretty clear, and the gold standard is to have it be perpetual. So you'd want it to be reviewed and approved by Mass Historical. If Mass Historical is not willing to hold it for some reason, that may be a separate issue, and you may still want to have a restriction of some kind. But to have it go beyond that 30 years and be perpetual, I was just, always looking for it to be held by Mass Historic or reviewed and approved by Mass Historical, so it can be perpetual.
Yeah, in a way, Andy, that one just before this about notice of sale almost should come logically after that, because the whole reason for notifying people of the potential sale and explaining to the potential new owners, blah blah, is because the PR remains in effect. So someone buying, a building or a property or whatever needs to understand that, hey, this property comes with this restriction, and it's not going away because the owner changed.
Agreed. And you'll actually notice in this provision that says that one of the reasons for providing that notice of sale is to give the opportunity for the grantee, in this case the society, because it's the high school, to explain the terms of the restriction and make sure that the new owner actually understands, because I have certainly found over the years in my career that a lot of people do not read their deeds, don't understand the restrictions on their property or what the requirements are. And as municipal worker, I often see people, they'll call and contact the municipality and complain about something, or be concerned about something, and it turns out in the end that it's actually in their own deeds. What's the question has already been resolved in their own deeds or is enforceable in their own deeds, and they just haven't been made familiar with them. And so when people are closing or purchasing a property, they probably shouldn't rely just on their attorney. They should probably review the deeds and the documents themselves. But the idea here is that they are still responsible for that in the end. This goes on to indicate with an assignment section that, the grantee, in this case, again, the society holding it against the high school, may convey that restriction to another entity. And there may be a reason that needs to be done. Maybe the historical society is no longer there at some point, it's going to be dissolving. Well, they need to be able to pass that on, hopefully properly. So there's an assignment clause in there to deal with, a situation like that. But it has to be an entity whose purpose is to promote historic preservation. Obviously consistent with those purposes. Another type of entity would not be appropriate necessarily. There's an alternate designee. So this is interesting. If the commission needs assistance, for instance, I will certainly say that unfortunately, Caitlin and I and the other staff in the office have only limited time in a week. And there is a lot of although you've heard it about government, there's a lot of process and bureaucracy involved with everything we have to do. So one of the things that may be helpful to the commission going forward is, as we get more and more restrictions around the city, is to have someone help out with monitoring and enforcing the restrictions. So this is an alternate designee. So the grantee, in this case, it's the society, but it could easily be you in a PR, may at its discretion remove it and replace the grantee with its designee to administer, manage, and enforce this restriction, provided that any new designee is qualified. So bottom line, I guess, is this is, consistent with, I guess, one of my concerns, which is that these PRs are lengthy. There's lots of provisions in them. Each building is it's sometimes a little bit different. The restrictions are adopted at different dates, and so they might have different language in them. It becomes hard over time if we have, hundreds or thousands of PRs, as we could in Newburyport, at some point, to monitor all these simultaneously. So having volunteers that are out there and can identify issues that are in violation of the PRs, or having a staff or consultant, that can devote time to this is helpful. Unfortunately, there's just simply not enough time in our, days to monitor all these, well, with all the other obligations we have. So unfortunately, there is an assumption here that, people might notice something and call it to our attention, or we might drive by the property and see something being done inappropriately. But it might be helpful, going forward, to make sure we have enough staffing that's adequate to monitor the PRs and at least flag them from the commission if there's someone who might be violating a provision. Then there's a provision here about recording an effective date. So it becomes effective upon the recording, and obviously it's got to be signed by Mass Historical. And in this case, we're stored at the Southern Essex Registry of Deeds. This is not an uncommon section in legal documents, an interpretation section. It just clarifies that, the document is going to be subject to applicable laws, and interpretations of, certain geography, that sort of thing. So, this is kind of more attorney's language, but it's not uncommon to have something like that. Then there's a provision dealing with amendments. So obviously both parties can mutually agree in writing to make an amendment to the document as might be needed over from time to time. But those amendments should be, as it's just highlight that there, shall be effective. Oh, sorry. Let me just highlight the right section here. Shall be effective when recorded at the Registry of Deeds. So. Sorry, my tool isn't quite working here properly, but at any rate, you could do amendments, but it's always good to, you really should be having them signed and recorded at the registry so everybody knows and it's on record what the changes were in the PR. I wouldn't rely on anything that's outside of that format because it's not in accordance with the way that PRs are dealt with legally. Then there's a couple of other things at the end of the document. So that's all the sort of legalese in there in the typical sections. Then there's the signatures and the authorizations. So this is one of the things that takes a while to get these documents reviewed and approved is there has to be a conveyance and approval by the city of Newburyport. So in this case, the city was conveying the PR and the city is agreeing to sign the PR. So this provision here is the city clerk certifying that, in this case, in August 13th, 2018, the city council voted to convey and approve the PR and in accordance with the state law, which makes it perpetual. So the city clerk is, in this case, the assistant city clerk was signing on the city clerk's behalf, but the city clerk is signing that it did indeed happen. And then there's the typical notary signature after each signature. And then there's the mayor's signature that the restriction has been conveyed. Obviously, that's the chief elected official of the city, so there's the mayor's signature. Again, a notary signature. Then there's the acceptance of the restriction. So again, you have the grantor and the grantee. The grantee here is the Historical Society, so they've signed that, indicating that they've accepted the restriction and agree to hold it and essentially enforce it. We have the signatures there, and then another notary blocks for both of those signatures. And then there's the approval by Mass Historical. And so this is the process that usually takes the longest as far as review is the submission and review by Mass Historical. That's largely because, just my own opinion, they don't have the staff and resources to keep up as most planning offices or government offices do sometimes these days. They don't have enough time in the day to review all the documents. So it sometimes takes a few months to get these things reviewed. We've had folks on the development side complain about that, and it sort of is what we all have to deal with. But that review is done. I should stop there for a second just to explain that usually, and the way this should work is that the person who's prepared the PR and put it in good format, it should be in the right format to begin with, and has all the attachments, should then be sent to Mass Historical for review. So the person who's writing it up, and again, I'm describing this mainly from the perspective where you commission members are holding the restriction. The person who's prepared it should submit it to Mass Historical and make sure that there's an initial review of that PR. That's their process to make sure that it actually conforms with their requirements and it addresses any particular concerns they may have. So they'll typically issue a letter back at some point. Sometimes it takes a number of months to review to get on their docket. But when they review it, they'll give comments back and clarify if there's edits that are needed, if there are provisions that are problematic for some reason, and that bullet list of issues needs to be addressed before it's resubmitted to them. But they'll oftentimes indicate if all those particular changes are made appropriately, that the revised version submitted will then be eligible for Mass Historical signature and approval. So the idea there is there's a draft review, just like there should be with you as a local commission. The person preparing it, oftentimes a developer or a property owner, should submit it for your review. They should make any changes that are deemed necessary by our commission and by this Mass Historical Commission. And then the final version should then be routed for the signatures. If there's major problems with the document or missing pieces or information that's needed, it might take several rounds of review that can add time, but hopefully people have done it right the first time and there's all the attachments and so forth, and there isn't a need for another lengthy round of review. So there's Brona Simon, the executive director and clerk of Mass Historical Commission, who signed that. And again, Notary Public's signatures next to everybody's signatures. There's Exhibit A is a legal property description. These are oftentimes included in deeds and things. I personally don't place a significant amount of weight on them, and they do help, but I've often found problems when someone's trying to transcribe all the meets and bounds. So it's actually better, in my opinion, to just reference a plan, but I don't object to the paragraphs. I just think they oftentimes end up with typos and things that end up being problematic. So if possible, plans are always helpful. And in this case, there's a reference to a source registry of deeds plan. Then there's the baseline. Let me just try to make this a little bit better. The baseline documentation plan. So this is a sketch plan of the building. It's obviously not showing the property lines, but it shows the high school building. There's the center arrival there. Shows the courtyard space in the new addition, and then there's the stadium is back here. Just orients you towards the building and clarifies which wing is which and which facade is which. So if you're looking later on in this document to the photographs, you can orient yourself properly.
Yeah, that's nice that they have that, Andy, where they show you which, they label the different facades. That's helpful because Newburyport, the streets, it's not, and everything, they're not nicely oriented north, south, east, west. They're at various angles, so it's helpful to have this. Yes, definitely. Actually, and it's funny because if I were the person prepping this particular PR, I would have actually put a plan that actually labeled the streets in there as well. They could have done a little bit more to even orient you better, but at least it does that. So. And there's the photographs. These are reoriented the page because of the photographs the way they are, but this just gives a caption for each photo explaining which facade it is, what date the photograph was taken. These are basically, usually when we say baseline documentation or photographs, it's to illustrate what the building looks like today. So that if something were unfortunately or inadvertently done to the building by someone, we'd have some photographic documentation of what it should look like, so it could be potentially restored or dealt with. So those baseline photographs are helpful, and there's a series of pages with different, photographs and orientations. It's helpful sometimes to have a plan that shows arrows and clarifies where they are, but that's not always in there. And then there's this important piece here. This is one of those pages I mentioned that for some reason at the registry didn't scan very well, but you can still read it. This is the baseline documentation and of the character defining features. So you all know that when we're looking at these are really important things to call out, because if you want them to be preserved, I think whether it was Glenn or Patricia that mentioned earlier, there's a paragraph that deals with that stuff. It's best to always call out something that you feel is a significant character defining feature, because it makes it clear in the document here that is important to preserve that particular feature, that feature is essential to the historic character of that building. So there's lots of things here, like, the shape and massing of the building, or the materials, the brick and, material that are used, or decorative and stylistic features by elevation. So on this particular facade, there's a wood portico, including ionic columns, tabulature, finials, and lettering. It's a little hard to read the font, but it's all in there. Cast stone sills, window sash light configurations, which happen to be 8/8. So there's notations of things like that, just to make sure that there's no confusion of which things are considered essential features that need to be preserved. So that's helpful to have there bulleted out like that. I think this seems to be pretty comprehensively drafted that way. And then that goes on for several pages because there's different facades, sections. This is really just it's not a great map. You really can't read it. You can't read it at all at the registry, actually, but this is supposed to be a scanned version of one of our MyMap GIS maps that just shows where the property falls and orientation with the streets. And as you can see, you can't see Toppins Lane or the building or High Street or anything. So it's not particularly useful as scanned at the registry. And one reason I would recommend we try to keep an original copy or a good clean copy of what's been recorded in the first place. Then there's the restriction guidelines, and I think Glenn mentioned this piece. This is as an exhibit, there's clarification of what's considered major or minor for different categories of work, so that people know whether or not, if it's minor, they can do it as of right, and if it's major, they have to come to, in this case, the commission for review. This particular PR being held by the society, the city would have to go to the society to do some major work and make sure that it meets sanitary standards and the society's approval. So there's clarification for paint and work on windows and doors, the exterior. So for instance, the exterior, the large scale repair or replacement of cladding or roofing, that's a major project, whereas spot repair of existing cladding and roofing, including in-kind replacement of clapboards, shingles, and slates is not
subject to a review because it's obviously just regular maintenance. So just try to clarify a little bit of difference between those two. There will always be, things that don't quite fall in there, and there's some caveat language to that effect, but this is meant to cover most things that come up on a frequent basis.
Yeah, and I would just add, you can see on most of these, they make a point of pointing out that these minor repairs, they virtually always, they usually reference that you're repairing or replacing with in-kind materials. So particularly like with windows, if you're, if you repair or in-kind replacement of an individual decayed window parts, like you've got a muntin that's rotted out or something, and you're replacing it with the same profile wooden muntin and all that, versus changing out a window and putting in one that's fiberglass clad or whatever. It's got to be the same material to be, and just a kind of a portion of something to qualify as a minor repair.
Right. On this next page here, I just highlighted this other section I thought was worthy of note. This is just to clarify, some people, the idea behind this PR is not to prevent modifications or alterations from happening necessarily, but to make sure that they're at a certain level, they are reviewed for appropriateness. So it says here that changes classified as major alterations are not necessarily unacceptable. Under the preservation restrictions, such changes must be reviewed by the grantee and their impact on historic integrity of the premise that's assessed. So this just clarifies that it's the obligation of the property owner to notify the grantee in writing when any major alterations are contemplated, and it may require a review. So it goes along with the legal language that's before in the document, clarifying that, per this exhibit here, this attachment, that certain things are subject to review and can't be done without review. Then further on, we have I think is the last thing, the Form B. So the last exhibit here is typical. All the preservation restrictions have a Form B that explain the history of, or at least generically, as best as possible, the history of the building or the significance of it, whatever is known. So there's a architectural description and so forth. I mean, you're already familiar with these, but this should be an attachment to the PR and explain some of the historical background of the structure. So that's the primary PR I wanted to review, but there was one other one I wanted to show real briefly in relation to this, or just to show another feature that this PR doesn't have in it. And so the one I wanted to show you is, let's see, there we go. This one here, which is this is the one for the old Kelly School building. So you'll see here, this is actually, as Glenn was noting earlier with the header, this is between the Kelly School LLC, which really is just a shell company for the developer that was doing the project, and the city of Newburyport, by and through the Historic Commission. So this is the most often the scenario you're going to see is where you are the one that's being, receiving the restriction and is going to enforce it. But what I wanted to point out in this one was, this one has reference not only to the existing conditions and what's being preserved, but also reference to a set of plans and drawings that are incorporated in the restriction by reference. And what these plans are in Exhibit G, it's referenced as, that those plans, although this language might have been drafted a little clearer going back, it basically clarifies in this document that they are allowed, as part of this preservation restriction that was being signed and recorded, they were also simultaneously being allowed or approved for certain modifications or work to be done on the building. So in addition to the baseline documentation we already saw in the last PR, this one, as you'll see, let me just scan to that now, there are, again, poorly scanned at the registry, just it doesn't seem to work well, but there are plans in there. This is sideways, but this is the Kelly School building, and what you could see on the clearer copy is specific plans called out that clarify work that they would be permitted to do, on the roof line and so forth. So anyway, the whole point here, I guess, is that PRs can actually, if it's known at the time, can incorporate specific improvements to be done that are acceptable, so that they're documented and approved at that time. In this case, that just worked timing-wise well for the developer, and the city was comfortable with the modifications that were being proposed. So those were incorporated in the PR, as opposed to recording the PR and then waiting later on to see if they were able to be approved.
Yeah, we had a similar example, Andy, with the old jail where Chuck Griffin was trying to get his preservation restriction done, and he had a number of things that he wanted to put in there as things that he had sort of pre-approved in this similar way. I don't know if you remember that or got involved in that, but it was a similar kind of situation.
Yep, yep. Yeah, this again, just referencing this, that grantors, this is reference to that an attachment there, that attachment G, Exhibit G, where they wanted to do specific improvements. Grantors reserved rights not requiring further approval by the grantee. So the grantor, this is the developer, reserving rights to do certain work that's shown in Exhibit G. This is clarifying. They wanted to make sure before they recorded this PR that there were certain modifications they could make, and those were referenced as another exhibit to the PR, and this is that language that speaks to them. So they were given the right, without further review approval by the commission, to do the work that's shown in Exhibit G. So I think that was the one thing I wanted to note in this PR that was different. Otherwise, it's largely the same structure. But again, I think it's a lot of time is spent on these PRs, and I don't think it's the most efficient way to preserve historic structures. In some ways, it'd be more efficient to have a local historic district. But that not being possible, there's sort of these one-off agreements that are done to more comprehensively protect a particular structure. So this lengthy process has gone through to develop these, but we can hopefully streamline that by having like I said, a clean word version template available for people that does meet the commission standards and does meet Mass Historical standards. And that way, before they even bother submitting something to you, it comes in the right format. And that way staff can be a little bit more helpful in that respect, given all the other responsibilities we have. So that's kind of what I thought was worth going over today. And not sure if the chair or other members have questions or comments or whatnot.
Well, I see Patricia's hand up. Let me just throw in a real quick question, then we can, Patricia, you can ask yours as well. And my question, Andy, was I know that on occasion interiors are addressed in a PR. Does that, I just want, have you seen that? Would you say does that happen pretty rarely, or what? I'm thinking of that so-called 1690 house, or the toll, that house by the toll factory there. I know there was.
Yeah, I would.
Yeah, go ahead.
Sorry, I would say that's relatively infrequent, but it can be done. But it's not something I see very frequently, and I don't think it's done very frequently. I think typically the primary concern is preserving the exterior that the general public is going to see on a regular basis.
Yeah, I would think it would have. I think where it would be relevant, I can think in the case of the Cushing house, for example, it might be relevant where the house itself is part of the interior of the house is part of the whole historical value of the whole thing. So to gut the interior would totally defeat the whole purpose of the thing. So that might be another case where the interior might be relevant. Patricia, did you want to ask a question or make a comment or what?
I just want to make a comment, and thank you, Andy, so much for going through that so thoroughly. These are really complicated documents, and we do hold a number of these PRs. I'm also, though, about to confess to heresy, I'm afraid. Because the PRs on the Custom House and Cushing and Kelly School and the old jail, they make sense to me and they're necessary. I'm glad there will be one on the People's United Methodist Church, but I must express some skepticism about PRs on private houses as the ideal preservation tool for the unmitigated good of all, I guess. As Andy said, if there's a local historic district, or in our case, if there was an eternally strong commission and strong ordinances, then ideally the city could protect its buildings without trading away the kinds of things that sometimes get traded away. And my example is the Gothic house off High Street near Kent. It's architecturally lovely, but it was also important because of its isolated setting on the hill, right? The view and the context. And then this commission, holds the PR, and then the lot was subdivided. So now there are these 4 new houses, a new street, a new traffic pattern. So, the city got the house, kind of lost the site. I don't know what the owner would have done without the PR. Were they going to raise the house to the to the ground? I mean, no, they were going to come in and go through demo delay. So for me, if there's an antique house in poor condition and an owner will restore it and put a PR on it in exchange for something, that's the ideal use of it. For me, I think PRs on these well-preserved houses on High Street that are worth millions to their owners only because they are already preserved, and then the city has to allow, you know, development on the lot. I'm not sure. I have to think about it more, read more case studies. Obviously, it wouldn't make sense for our commission to hold PRs on every house in town. It is a burden to us that I think we should assume very carefully. And, you know, nobody ever comes looking for a PR because what they really want is to preserve something. Preservation is sort of the cost that they know they have to pay for the development that they want to do. And I think sometimes that development can compromise other historic assets. So I'm not going to ever argue against one on a private house, but I may at times lack unbridled enthusiasm, just for the record.
I don't think you're alone there, Patricia. In fact, Andy, I think I've heard you talk about a similar thing and reflect
Yeah.
the
Could I
city's
comment on
attitude in
that?
general. Sure, please
Yeah.
do.
Thank you. Yeah, you and I were probably thinking share about the same situation, but I think it was the one on Merrimack Street. But I've seen at least one instance, if not more. Applicants and their representatives can be good at looking for the easiest way to get through the process, and sometimes that can be leveraging one board before approaching another board. And I've seen at least one instance, if not more, where the applicant's representative will come to the Historic Commission, for instance, and ask if the commission is interested in holding a preservation restriction on a structure. It sounds like a great discussion, right? It sounds like something the commission would want. However, it's worth noting, and that doesn't mean that the commission shouldn't want the PR, but what was potentially being done there in the behind the scenes, or the ulterior motive, was to use that confirmation from the Historic Commission that a PR is desirable in quote, in the public interest, to then apply to the planning board or some other permitting entity and argue that that confirmation of public interest already satisfies, say, a zoning provision that is requiring a so-called public benefit to get a certain type of development relief. So that goes back to what Patricia was saying. So I guess what I'm getting at here is, keep in mind that if a developer or their representative is coming to you and saying, hey, can we do this good thing for you? There might be a reason why they're looking for that confirmation from you. It may be that they're looking to do some other type of project, and whether or not you support that other project is actually relevant too. So for instance, there was another one there are two ones. One on Water Street. I'm thinking of one on Merrimack Street, and the one on Water Street, I think, was a scenario in which the commission was asked if they were interested in, if they thought it was important to preserve a structure. And then that reference to the importance of preserving the structure was then used to argue that the whole modification or expansion project the developer wanted to do was necessary to preserve the building, in the way that the language was sort of contorted. So, again, I just think that it's important for us all to know how the regulations work in conjunction with each other, how, boards and their permit reviews might relate to each other, and how a developer can use, certain mechanisms to get to their end result. And we need to make sure that we're not, our ordinances and provisions and regulations are not taken advantage of by someone who may have a particular interest in mind, but may not necessarily be in the public interest.
Yeah, and Joe, I see your hand up, so I'll give you the floor in just a second. I just want to add to that. I've been much more wary of that as I kind of learned through experience, perhaps the hard way. But anyway, Andy is absolutely right about this, and the ability or the inclination of an attorney, let's say, to try to maneuver through the system and maybe leverage one board against another. At any rate, what I now do is, and in the ones, everyone I can think of, they've been pretty open, even in those initial meetings, that they've said that, yeah, we want to do this because we need to get exempt from maybe some environmental regulations, or we want to do a Section 6C, or whatever it is, infill. So now, when I'm very careful with how I write, or how any motion is phrased, and how that is communicated to the other boards, whether it be the planning board or the ZBA, so that they understand, clearly, what our position is, and not feel, not be, so that they're not they're not exposed to it being mischaracterized by the applicant when they're before that board, as being something other than what we're okay with. Anyway, whew. Joe, did you want to ask a question, make a comment, or whatever?
Yeah, thank you, Glenn, and thank you, Andy, for your thorough explanations. That's going to be very helpful because I'm working on a PR right now for the library, and I've just begun it, so that this will be very helpful. But my question, well, actually, first observation. It seems that in the item number 16, talking about inspections, the last paragraph there pretty much relieves the grantee of any legal obligation to enforce this. They don't have to do anything if they don't want to, apparently. And when I think of some of the institutions that are involved here, it makes me think that, well, if there's no major work that's really undertaken over a period of years, the institutional memory and the leadership may change in such a way that no one really even is aware that this thing called a PR exists on their building. And so it seems without some formal methodology for reviewing these on a regular basis, annually or biannually, that this could just vanish in the
Yeah,
in the world of historical preservation. So that's an observation. So let me turn this into a question for us, the Newburyport Historical Commission. When we are the grantees, what is our procedure or our methodology for actually reviewing these on a regular basis to make sure that the grantor has not done something, shall we say, accidentally, that actually transgresses the intent of the PR?
Well, I can say a few words about that, and then maybe Andy can add to it, Joe. The very house that Patricia mentioned a few minutes ago on High Street near Kent, that's this really neat Gothic house. Anyway, it has a preservation restriction, as she said. It turned out that unbeknownst to the commission, it has this PR, they started building a deck on the back, which obviously, well, obviously not, but anyway, it was violation of that PR. We learned about it, or it came to the attention of someone in the department through an abutter. And this goes back now literally a couple of years, because I remember this was before I was chair. I was actually very new to the, just around the time I joined the commission, this came up, and there was, so we sent a letter, it didn't get delivered, so, months went by. In any event, the last communication with that property owner was, I think, around last fall, and they were supposed to get back to us with either their plan to remove what was started or submit plans for deck for us to review for possible approval. And it's been on my mental to-do list to go up there and see if anything has changed up there. And it's time for another letter to them saying, okay, you said, we'd hear from you in the spring. Okay, it's July, August, whatever, September, by the time we probably get around to it. What are your plans for this thing? If you're not going to do anything with it, you should remove. There's like some pilings and posts and things like that. So this doesn't actually answer your question, Joe, but it's a good example of the kind of thing that can happen. And I think you're absolutely right that these things can very easily, kind of get lost in the mists of time, so to speak. And that's why, Andy has commented on it, Patricia's commented on it, you've commented on it. These PRs are probably not the ideal way. They're the tool we've got, I guess. But yeah, now we didn't have until a couple of years ago a zoning enforcement officer, but Andy, to my knowledge, Jennifer doesn't go around, following up on any of these kinds of things, right? although I guess she would, if someone actually applies for a building permit, see, if someone sneaks something on the sly, that's, then it's more likely to sneak past. But if someone applies for a building permit, then that's going to, be reviewed by Jennifer and all that, and she would probably, I imagine she would be able to see that that the property had a preservation restriction. Am I wrong there, Andy?
Sure. I don't want to speak for Jennifer, but I work with her regularly. Obviously, she directly reports to me, although I think she does a great job on her own. But her job is to enforce the zoning ordinances first.
Right.
Any sort of ability that she has to keep up with the PRs is secondary. Unfortunately, like I said, I just pulled up for your reference. This is
Yep.
a web page that Diana has been posting where we keep all the PRs that are held by the NHC. Those are just the ones held by the NHC. And as you know, there are historic property surveys in the city, and for all those that are contributing, there could be, think about how many there are. There could
Yep.
be a ton of PRs. So it
Yep.
really is not realistic. Glenn's point, and the ones that were made a moment ago, it's really not realistic. It is not sustainable, to use a common word environmentally. It's not sustainable for us to be able to keep up with all the different PRs, all the different buildings, and there sometimes different language in the PRs or provisions or exceptions, and the ability to be out there in the field monitoring them. Unfortunately, we spend a good amount of time on lots of procedural things that detract from our ability to do some of that important monitoring or enforcement work. So Jennifer is only one person. In my opinion, that's not enough. But we do have limited funds and limited resources. So she does work with me and with Caitlin. We do keep up with what we can. She will look for these and try to identify them as she's able to. Obviously, that's something that she definitely makes an effort to do. But there, I'm sure have been and certainly will be, in time in the future, things that are missed because there are just too many pages of documents, the regulations, the PRs, being out in the field. There's only so many properties you can keep up with there when construction work is being done all over the city. And there's lots of procedural things we have to do to review even the permits that are coming across our desk, in an active way. Never mind the things that might be happening behind the scenes, maybe without permits. So yeah, at any rate, we do try to do this, but that's one of the reasons why I want to see the preservation restrictions uploaded to our permitting software by property, not just the permits that are issued by our ZBA or planning board, for instance, so that it can all be found in one place by everybody, including not only the staff, but the general public and all our board members. But it unfortunately just is not realistic for us to be able to keep up with it all. It's unfortunate, but it's just a cumbersome process.
So it sounds like, if I understood what you just said correctly, Andy, at the tail end there, that since it's not listed in, in the property listing, there's no kind of automatic flag, so to speak, that, when Jennifer's just doing a routine, checking out a property for age or whatever, there's no particular flag that it indicates, oh, there's a PR on this particular property. So in other words, unless she looked, she might not know.
Yeah, no, sorry, I should have clarified a little better. That's a great question. One of the reasons why I wanted it to be in the permitting software is, so we have GIS information that's mapping layers. And one of the features of this permitting software, we're still working with the vendor to get it up and running, but the feature that it will have is it should flag for Jennifer as zoning enforcement officer or anyone else, the building commissioner, myself, anyone else involved. It should flag what zoning district a particular property falls within. And that will tell us essentially what the, immediately flag what the requirements might be under zoning and make sure there's no confusion. It should also prevent any confusion like that for the applicant or anyone else involved. So the idea here with the PRs is that if the PRs are actually uploaded or at least reference the book and page and whatnot is referenced in that permit tracking software, by property, just like we list assessor's information by property, that it would automatically flag, maybe an icon essentially would pop up or a field would be filled in. We're working on the features right now, but it would flag it for us. So we would automatically not have to do digging through a bunch of paper files that maybe haven't been scanned yet, but would immediately pop to our attention.
Yeah, that would be good. Whew. Okay, well, that's helpful. So Andy, last question, I think. So, you're working on, Microsoft Word. Pains me to say that. But anyway, an editable version of these, like a template. What's your how is that work going along? Is that something that you and Caitlin expect to have available pretty soon?
Yeah, again, I'd like to just, I'd prefer to hear back from Michael Steinitz and make sure that we're using something that he feels is the most recent, acceptable version. I obviously would want to take a scan through it, make sure there's nothing that sort of bizarre sticks out in there that
Right.
wouldn't make any sense. But the idea there is to have a good, clean Word version. I don't want to take a PDF and convert it because they come out pretty messy.
Right. Yeah.
So yeah, it could be just a matter of days, but
Okay.
we've gone back. I think we were checking, Caitlin and I were checking with Diane to see if we had a Word version of the high school, the Kelly School one. But in either case, I think because there are ones that have been done more recently than the Kelly, for instance, that we confirm a version that Mass Historical thinks we should be using, because obviously that's the format that they're going to want to approve anyway.
Yeah, I'm thinking of Joe because he's going to be working on the library one. That would be sort of similar to the high school, and that's a city-owned property and so on.
Yeah, I think what we would do is I notify the commission when we've posted that page so that the template's there. Joe could use that, and it will also reference it.
I have that. I have the Word version, and it's okay. The parts that I'm interested in are not going to really vary. I mean, I in terms of documenting the description of the building and the features, and providing any visuals such as photographs and a key plan, I can adapt whatever I do in that Word document to any forthcoming changes from the MHC or others. Not a problem.
Yeah, that sounds good. And it just occurred to me, Joe, that, with your architectural experience, you're the perfect guy to help them, especially that baseline documentation. I mean, you're ideally suited to help them with that. So thanks so much for agreeing to do that.
Well, don't jump to any conclusions, but I'll do my best.
Well, I have great confidence. All right, do you want to move on to the other thing you wanted to talk about? I know there was actually, why don't we kind of sandwich in between this discussion and the one about the survey, Andy? I know there were a couple people were talking about what exactly does it mean when we say preferably preserved and so on. I know Patricia has done, did quite a bit of research as she's, before the meeting started, she was telling us about that. So I think she can shed some light on this. I know Joe had some questions, others may have as well. The phrase preferably preserved, oh, thank you for showing that. Yeah, it can be a little, I think, personally, I think it's the preferably part of it that maybe kind of people scratching their heads, I know it means that, yeah, it's historically significant and we don't want to just forget about it. It means we want to preserve it. So the preferably is kind of a little bit questionable. But anyway, why don't I hand it over, Patricia, why don't you share with us, what you found, and why don't we start with that? You there?
Yes, I'm here. I couldn't hear you. Yes. Okay. So I looked at the policies and procedures of other Mass historical commissions to see how they talk about historical significance and how they talk about preferably preserved. So I'm just sharing this information for the purpose of, making comparisons. The towns I looked at included, but we're not limited to, Salem, Marblehead, Nantucket, New Bedford, Cambridge. I look closely at Cambridge because Newburyport has adopted its window guidelines and because its historical review process is very thorough and detailed. So starting with historically significant, right across the state, properties are treated as historically significant either because of their age or their inventory status, meaning they've been listed on a state, national, or local register. For us, it's the district data sheet too, which is why it's important to properly inventory and identify and have comprehensive lists. But also commissions across the state can determine just by majority vote that a building is significant, even if it doesn't qualify by age and is not on an inventory list. That vote sort of allows for the capture of properties at the discretion of the commission. That's what we did with the Christian Science Church building last week. It was listed as intrusive. It wasn't really that old, but by saying it's historically significant, okay, now we've got it. Okay, so procedurally, in my opinion, the presumption is that all the properties in the DOD and DCOD that come before us are already listed as historically significant, or that we're going to vote to list them as such. And that the vote and our discussion is more of a formality designed to let the owner maybe have a chance to contest the designation. As you remember on 12 Harrison, the owner, you know, argued that the house was not historically significant because the roof line had been altered and there was vinyl siding. So I think of this part of the hearing is just the due process requirement to let owners argue against significance. Some towns explicitly say in their historical commission rules that everything within the historic district is historically significant. And they say the purpose of the vote is just to exclude anomalous properties. So, you know, on the Cape, the town of Dennis says, you know, everything can be presumed to be historically significant and preferably preserved. The burden is on the applicant to make an argument against either of those designations. Very interesting. In Boston, everything that's in a neighborhood overlay district is significant. New Bedford says anything within 150 feet of an historic district boundary is also significant. Cambridge says it's significant by itself or in the context of a group of buildings. You know, Newton says everything older than 50 is historically significant. So Andy has up on the screen, this is like the standard language in the state, but I will say from my reading, the term historically significant is big, you know, it's capacious, so to speak. And the word significant is not dwelled on. The standard isn't that a property is substantially or impressively or inarguably, historically, architecturally important. The word significant means in its plainest use that it's a sign, that it signifies or indicates something, either a style or a period or some part of the city's history very broadly. I know when I started on the commission, that hung me up, right? Historically significant. But again, when I look at how other commissions treat it, they're using significant to just mean, you know, it indicates something. Massachusetts has these two prongs though, and that we add preferably preserved, and everyone hates that term. Other states just say if it's historically significant, then it triggers review. We've added preferably preserved. And so as defined by Mass Historical, it means it's preferable that the building be preserved, restored, or rehabilitated rather than demolished. Okay, so again, that language is in our ordinance. Some towns, most do not define it further, but some historical commissions explain what preferably preserved means to them. So some examples are preferably preserved relative to the empty lot that would be there if this building were razed to the ground. Or preferably preserved relative to the proposed replacement structure. So if we stick by this definition as meaning, you know, the city would rather see it preserved, restored, or rehabilitated rather than demolished, I think it's very easy to understand. If we're saying it's not preferably preserved, of course, we're saying the city doesn't care whether the house sort of lives or dies in its current form, its historic form. It's not a candidate for preservation. It's not a candidate for anything. Cambridge says, they acknowledge that the only way they can control the design of new construction to make sure it's compatible with the streetscape and neighborhoods is to just say, yeah, everything's preferably preserved. So I think of it as, it's not a gold star to say that the house is beautiful.
Right.
It just says, don't knock it down. It makes a contribution to the impression that the city is a city of architectural history and history. And so I always want convincing arguments to say why it's not preferably preserved. So for example, on Plum Island, you know, Christopher Fay and I tend to say that, okay, it's 1920s cottage. Maybe it has bad additions, but it is historically significant and preferably preserved because we're comparing it not to a 1920s perfectly preserved and restored cottage, but two, maybe also the 5-story super house that would be there if it were demolished, right? And I know people tend to say Plum Island's already been ruined, there's so much new construction, but I don't find anything in the ordinances that sort of supports like, oh, it's too late for this part of the city. So I tend to think of everything as preferably preserved, and then argue that it's not. And I looked around other states too. New York says a candidate for preservation is a building that represents an established and familiar visual feature of a neighborhood. Some cities, and I do think we should think about this, use preferably preserved as a label only for a certain part of a house. So sometimes we've had these rear shed additions, you know, from the 60s or 80s. And we're not saying that they are preferably preserved. We're, you know, I think we should be clear. The house is preferably preserved, but maybe the shed in the rear is not preferably preserved. You know, like 342 Merrimack, right? We said the house is significant and preferably preserved, but the rear shed addition is actually not significant and preserved. I just think we have to spell it out.
Mhm.
And then just a couple more things. I still think, I thought our terms were awkward until I saw some that, you know, some towns have these multiple designations, preferably preserved significant building. So some towns say it has to be either historically significant or preferably preserved. I'm trying to think of what that would mean. I'm not sure. Preferably preserved, like maybe, you know, the lighthouse house out at the corner of Water
Mhm.
and
The
Ocean
range light.
Avenue.
Yeah.
Right. So it's not, it doesn't meet the historic criteria, but if somebody was going to take it down and put up, you know, a 10-story cement building, you know, we would want to say it's preferably preserved, even though it's not, it doesn't meet the age category. And then finally, I just want to say, this is all part of our demo delay thing. And I was very intrigued to see that some cities have demolition denial. Like, you can never take this down. Salem on their application at least asks, what is the justification for demolition? I know we say, what is the reason? The word justification, I think, appropriately communicates that it's inherently not rational or just.
Right.
So you have to build a case. The answers that we get under describe reasons are things like, you know, we need a larger closet, we need laundry space. Okay, the house is 400 years old, but I really want a headroom, whatever. Often on our applications, when it says describe alternatives to demolition, it's blank.
Yeah.
And I never ask questions about that. I never bother. I think I should, you know, from now on, ask those kind of questions. I think that if we kind of ignore this clunky phrase about preferably preserved and just, you know, make it simple for ourselves and ask better questions about alternatives. And by the way, I see that there are towns that impose fines for non-compliance with historic district requirements. There are many states that have demolition by neglect ordinances, you know, Rhode Island, Virginia, North Carolina, meaning you are not maintaining the exterior walls and the chimney and all that. And so, you know, they're trying to arrest the neglect.
Right.
And so, you know, as our ordinances go, I think they're not the most aggressive. They're not the mildest. Portland, Oregon has a deconstruction ordinance that says if you're allowed to demolish something pre-1916, it has to be demolished piece by hand, and you must salvage, donate, or sell all historic materials.
Wow.
So that would, you know, there's way more, but, you know, it's just uniquely fascinating to me. But that's my sort of take on, it's very clunky to have this two-pronged process, and we in Mass are alone in having it and alone in using this weird preferably preserved term. But yeah.
Okay. couple of quick comments. First, in the verbiage, Joe, that I sent to you in my email, I copied that. There was a definition of what is historically significant building or structure over there in the DCOD that wasn't as elaborate as this, and it was just it just said a structure that's basically listed in that that list. It didn't have the reference to 75 years, although I knew about that. I'm glad to now know, okay, here's where it is. And I'm especially glad that number 4 is any principal accessory building designated by the commission, because as you pointed out, Patricia, that's what we did the other day or 2 weeks ago. And I'm glad that what we did was legal, because if it was strictly only those things that are listed, then obviously we wouldn't have been able to designate that as that church or former church as historically significant. So that's the first comment. And the second comment I wanted to make was, what you sounded like, my understanding of the term pretty much is in alignment. So let me test this theory. My understanding is that preferably preserved, well, that if a building is historically significant, it's always preferably preserved unless it's either A, caving in and like beyond repair, or B, has been so extensively altered, changed, remodeled, added on, subtracted from, etc., that it's not even recognizable as an old building. And we had one of those up on way up on Merrimack Street, past where the old Gold building was there, where there was a house that it claimed, it started out, oh, I don't know, mid 19th century or something, or maybe even earlier. That somewhere in there was a timber frame, something, but when you drove by the building, you'd think it was built in the 60s. It totally was unrecognizable. So there was like literally nothing left that anyone would recognize as historical. So those are the two. So do those two categories, would you say that was pretty consistent with
Oh
what
yeah, that makes total sense to me.
Yeah, that's kind of how I understand it. And any comment from you as to this, either the way I stated it, or how we kind of look at this?
No, I mean, I don't necessarily, I'm not necessarily uncomfortable with the language that's in our ordinance here for, being in the public interest to be preserved rather than rehabilitated. I do think it's, I've definitely seen the awkwardness over time of our two-step process in which we're deciding whether the building is historically significant and then deciding if it should be preserved. I think the real question should be, I mean, Patricia pointed something important now, which is, is there another evaluation that could be made, which is what's proposing, how does that compare against the preservation of the building?
Well, I've kind of been evolving that procedure, Andy, and maybe the folks on the commission have noticed this, where it's it's not the usual, the original step 1, step 2, as you just described it, but the first step is, the decision is, okay, it's one of these three things. It's A, not historically significant. It's historically significant, but not preferably preserved, or it's historically significant and preferably preserved. It's we decide it's one of those 3 things. That's step 1, and step 2 is, if it's either the first 2 of those choices, there is no step 2. If it is the third choice, which is significant and preferably preserved, then there's a public hearing where we review the demo plan, which I think is consistent with what the ordinance calls for.
Yep.
So, it kind of makes it, I think, a little bit clearer, because I know a few weeks ago, some of us were confused about, okay, this whole, when we're making that first decision, I'm trying to make it very clear to everyone on the commission that, okay, if it's either A or B, not significant or not preferably preserved, even if it is significant, then that's the end. There's no public hearing, and they just go along their merry way, get their demo permit or whatever.
Right.
If and only if it's historically significant and preferably preserved, do we get to do a demo review where we review their plans. We have some kind of say in what they do or don't do, and so forth.
Yeah, I think that's an important point.
Yeah. So I try to make it really clear on that. anyone, I see, oh, Joe, I see a hand up. Did you want to ask a question or make a comment?
Yeah, thanks. I have been confused by this also, being a new member on the commission, and have gone back on a couple of occasions to review the procedures in that Article 10, Section 5308, which follows, I believe, the definitions that you're pointing to. But as I read this, the first step is a demolition permit application, which goes to the NHC because the building has already been identified as historically significant. So I believe this first step is really sort of a rubber stamp. It's the NHC confirming, yes, that it's historically significant and might be considered or should be considered for preservation, because that second part is then part of the demolition plan review. And that is apparently, it seems to be, where the formal consideration for preservation is actually undertaken. It's in that demolition plan review where you have all of the requirements, the plot plan, the elevations, very clear descriptions of the proposed alterations for the structure. And then when I read that paragraph C under demolition plan review, actually paragraph, it's at the bottom, paragraphs 3 and 4 underneath that, it seems that after this discussion takes place in a public forum and you talk about the attributes of the historically significant building and what's being proposed, then there's a determination of whether it should be preferably preserved. So number 4, if the building or structure is not determined to be preferably preserved, or if the commission fails to file its report with the building commissioner, then the building commissioner may issue a demolition permit. But the way the flow of the review procedure works is that it's that public forum that helps the commission understand whether the building really should be preferably preserved and to grant the demolition permit of right or to impose a demolition delay. So it seems to me that there's significance in this idea of preferably preserved as opposed to historically significant. And that's the one sticking point I keep coming up against when I read this.
Glenn, could I make a comment?
Yeah.
This is Andy, just a more global comment. I was listening to the comments that were just made and everything else we've discussed tonight about the PRs, and, we have the DCOD, the DOD, and then this demolition delay ordinance. It's certainly apparent to me in the time that I've been here that we have these sort of patchwork of regulations, local regulations, plus the individual preservation restrictions. And we sort of had this patchwork because there's not been the sort of, it's not been politically palatable to adopt a local historic district that covers the entire DCOD or demolition control area that is the National Register Historic District, or even something more substantial than the Fruit Street District. So we have a convoluted set of processes that are intended to sort of preserve the structure from demolition, and if possible, as a next, threshold, at least, try to preserve some of the architectural detailing and features, but it's certainly not a comprehensive program that we have, and it's a patchwork that's been the best that has sort of, been politically palatable to date.
Yeah, that became apparent to me some time ago, Andy, and yeah, I would agree completely. And Joe, that's kind of what tends to make it a bit confusing. And I think I mentioned this.
Glenn,
yeah.
Yeah, Glenn, I don't mean to propose any alternative way of doing business here. I'm just saying that, what this means to me is that there is significance in the idea of something being preferably preserved in addition to being historically significant. I mean, that's really my takeaway from reading this. And should it be a separate discussion, or can it be grouped with the recognition that a structure is historically significant? I guess I would want to really benefit from the discussion of the particular structure in question and its attributes as a historically significant structure before I determine whether it's preferably preserved. So
Yeah.
that's the way I would feel about it.
Yeah, and typically, I think that's typically what we do. Sometimes in that initial presentation, the applicant will, go on to describe what their proposed plans are and stuff, which isn't quite relevant just yet because, we haven't, that's supposed to be part of the demo plan review, but typically, very, very often they do that anyway. But you might recall, well, I don't know, I can't remember exactly which ones you've heard not, but often they'll give a recitation. Well, sometimes it's kind of a slam dunk in that it's listed as contributory, it's got a Form B, it's, maybe some famous people live there, whatever. So that it's, unless, like I say, unless it suffered a fire and there's nothing left but a smoldering crater or something like that, it's obvious that it's historically significant. And we want to have some control over what happens to it. So therefore, we decide it's historically significant and preferably preserved. Does that make sense?
Yes, it does. Thank you very much.
All right. So it's starting to get a little late, but I know we wanted to talk about this this last topic, which is that historic structure survey update. I know Andy and I have mentioned, I know Patricia knows about it. I'm not sure if the whole commission is aware of it. I think we did actually brief the commission at one point, but I'm not sure. It might have been before Peter and Joe joined. At any rate, why don't you, and Andy, since I assume it was you or Caitlin or someone asked to put this on, why don't you go ahead and tell us what you want to say about it.
Sure. So this is, I'll just give a brief summary, and then if you have questions or comments, I think you and Patricia had wanted to sort of circle back and get this project going. The Sarah White, this is just a snapshot of the application back in 2016 that former Chair Sarah White had submitted for the Historic Commission. It was an application to the Preservation Committee, which provides a recommendation to the City Council as to whether or not to fund project with CPA funds. Funds were appropriated, $15,000 were appropriated per this application to do a project to basically update some Form Bs so that some of the historic information we have and the inventory and properties that might be considered significant or contributory are up to date. And also that means both adding some structures and potentially updating some forms that are out of date. So just pulling up the application form here just to highlight, but there were three sort of goals out of this. If it's clarified in the application, that was only expected to cover about 150 structures because of the time it takes to prepare these forms and the idea that there'd be, unfortunately, the staff do not have the time, unfortunately, to do this project on our own because we have other obligations to deal with already. But the idea was that at least we could oversee a consultant who was going to do all the legwork behind preparing or updating Form Bs. So the idea was, per this list 1 through 3, to capture printable structures that are within the National Register District, but which lack a Form B, survey historic accessory structures such as carriage houses, barns, and the like, and prepare Form Bs for each, and update existing survey forms whose historic or architectural information is known to be incorrect. This obviously assumes that the Historic Commission or volunteers or anybody else who's interested, maybe the Preservation Trust or others, are interested in spending some time working, collectively and with the consultant to do this work, because it does take some time, and unfortunately that money's only going to go so far. I always hesitate a bit before I think it's worthwhile to spend money on a consultant, because I prefer to have the money used in-house and, not pass it on to a consultant. But sometimes they're necessary to do these things, either because we don't have the staff or resources of our own, or because they have an area of expertise. So in this case, I do think this is a project that warrants, spending some money with a consultant on. But I think it'd be best if there's some sort of consensus and agreement, maybe it's a working group or a regular meeting with the commission, to make sure that the consultant is working on those particular structures that are considered most important to address with these Form Bs. So the consultant can't come into the city of Newburyport and say, here are all the Form Bs you have. Here's what I think should be done. It's best if the Historic Commission dictates where the priority should be. So Sarah was capturing the full breadth of what could be done with these Form Bs, but given the number of structures in Newburyport that are historic in nature or have any historic relevance, which is quite a few, there should be some sort of guidance given to the consultant. And unfortunately, I don't think it's because it's sort of a chicken or egg kind of thing, trying to go through the process. Unless the commission can clearly identify 150 right off the bat and say, you know, consultants give us proposals, you might have some iterative discussion with the consultant as they go along about which ones to include, unless somebody has a pre-prepared list that, you know, nobody's going to debate about. So at any rate, the idea here with this grant was to spend the $15,000 for the commission to, you know, have our office and a consultant assist with updating Form Bs as needed, and then making sure that those are used by everybody going forward in the way that the existing Form Bs are used. And that like I said, an RFP would be issued to pick a consultant. We'd look to the commission, Preservation Trust, and others to recommend consultants, as you know, Mass Historical and others, just to make sure we're using a consultant that's well qualified and you know, will provide a reasonable price. And the $15,000 were appropriated. The problem has been that due to our bandwidth and changes in the commission chair and you know, lots of other things that have gone on, the project hasn't gone off the ground yet. So there's money sitting there that can be done for this purpose. And the CPC does require sort of regular updates to see where grants are, and funds can be returned to the CPA pot if they're not being, you know, mobilized. So I think it behooves the commission to pick up this project, but you'll have to recognize that Caitlin and I only have a limited amount of bandwidth we can absorb in this particular project because we have so many other things in our plate already. So we'd want to work with you, commission members, and any volunteers that are interested, or Preservation Trust or others, to, you know, reach out to consultants, you know, prioritize which structures should be looked at for the Form Bs, and then review the Form Bs that are prepared by the selected consultant so that before they're finalized, the commission is comfortable with the Form Bs that have been prepared.
Hey, Andy, a couple of quick questions for context here. When Sarah put this together, there was a lot of focus on Form Bs, but my understanding from discussions with, I think, both you and definitely with Jennifer, is that what the ordinance looks to is not whether or not a property has a Form B, but whether or not it's listed as contributory in that list. Is that correct?
Yes, that's exactly correct. The Form
Okay.
B is a baseline for providing some important information about the structure, but you're right, it is that contributory listing, which I'll pull up on the screen as we're talking, just to show everybody what that is.
And part two of that question is, so it's the list that's actually the key to protecting these structures a bit more. I mean, Form Bs, I'm not to say they're unimportant, but it's critical that things are on the list. And I noticed it's possible for something to be listed as contributory and not have a Form B. So how do things get on the list?
Right. So the commission actually has to update that listing. This is the old scan. I don't even think we have an electronic version of this document. So this is the scanned listing, but the commission has to agree to update this listing. So Glenn was mentioning the contributory status. This status here, column on the right, is indicating whether it's contributory or intrusive or some other status. But with all the ones that are contributory, you know, you're right, they don't all have Form Bs, but the Form B would ultimately be required for a PR anyway. So
does this, now what we're looking at here, is there any indication or flag on here that would indicate a Form B is either exists or does not?
Actually, that is, although it's not on this table, I don't think, what we do have is on the web page itself. You can go by street name, so by, you know, A's or Ashland, you know, et cetera. So you can scan down this list. Diane made a nice, convenient, you know, cheap button here. You can go right to M and look through and see if whatever address is in there. If it's not listed here, unless there's, you know, an odd discrepancy where something wasn't transposed correctly, it means that it's not here. So if you see it skips from 14 to 28 Madison, you know, apparently we have nothing for those in Form Bs.
So could you go back to the list again?
Oh, yeah, sorry.
It's all right. I can wait. Because there were some numbers like handwritten in there. I was wondering what the significance of, if any, of those is. I thought they might refer to like a Form B or something. Like you see like 2629 there on the number 3.
Yeah, I don't know. I don't know. That might be the form number. I don't recall off the top of my head. I apologize, but that may be the form number.
All right, we'll look into that. So if I understood you correctly, then if we, let's say we take a stroll down, you know, some, name a street, Warren Street, right? And we, and there's some houses there that maybe were not old enough as of 1980, 81, just so everyone is on the same page. This list was compiled about 80 or 81. Isn't that right, Andy?
Yeah, that sounds correct. Yep.
So let's say now it's like 40 years later. So there are a lot more that are now 75 years old or whatever. So would I be correct, Andy, that we can say, okay, here's a list, these addresses, you know, date of construction and, you know, style, whatever. We want to add these to the list and just have the commission like either vote on either on each one or as a group or something. Is that all we need to do to add these to the list?
Yeah, I was just actually looking for a provision I wanted to highlight in the demolition control overlay district.
Okay. Yeah, there is something in there about automatically added or something, and that's
right.
I always wondered about that.
I just wanted to pull it up, so bear with me just a second.
Yeah, sure. Patricia, did you want to get a word in? I see you.
Oh, yes, I wanted to say that I think there's a couple things that could be free. One of them is I know that the Preservation Trust has this historic plaque program, and that their title examiner has, you know, updated a lot of information that people didn't know about how old their houses were. I'm sure that they would be willing to share that information with us. Also, I can contact Daniel Blueston as the director of the New England Studies and Historic Preservation Program at BU. And I'm not saying this would happen now, but so imagine next summer when we're not thinking about, or next spring, we're not thinking about the pandemic. I know that this is amazing field work for preservation studies graduate students to be up here in Newburyport walking around saying, okay, we really want to capture the barns, the carriage houses, these other kinds of structures, because those are the things that really show up on the Form Bs. So there are ways of stretching the 15,000. And then Glenn, maybe you and I can talk and come up with a list of, you know, some consultants that we think might be appropriate for some of the more complicated stuff with the research.
Yes, and perhaps there's a certain attendee who is one of the a member of the trust who might be listening to this and thinking that we may contact that person to talk about some context here. I'm referring to Ms. Niketish, that was on the attendee list. So this is a topic that I'm sure the trust would be very interested in.
Glenn, this is Andy. I just pulled up that section from the demolition control overlay district ordinance. So this section just clarifies the process. So the commission obviously wants to get that information in order, but then goes through the procedure to add it to the National Register. The idea there is that it would be added as a contributory structure in addition to the ones that you already saw listed.
Well, it says subject, let's see. Upon such properties being added to the National Register in accordance with this Act of 1966 as amended. So I see it's not exactly a link to that. Does anyone know what the requirements of that National Historic Preservation Act?
Yeah, and actually, I believe Stephanie has her hand raised because she'd like to speak to that. Is that
Aha, I suspected you might have something to say. Stephanie, it looks like talking has been admitted or permitted for you. Did you want to make a comment to this?
Thank you very much. So I am concerned about this, and I wouldn't have raised my hand if you hadn't mentioned me. But the process to add any new structure to a National Register district requires the owner's agreement. So, and Andy, you know, if if I'm wrong, tell me, but you know, that is,
No, I agree with Stephanie on that. Yeah.
so it would be a waste to spend any time or money on buildings which are not now listed in our our National Register Historic District, if the owners don't agree.
Okay. So each
I would
owner
agree
has
with
to be
that.
contacted and informed, and it probably be best to have that agreement in writing
Yeah, that would be a good
for the
idea.
obvious reasons.
I think, you know, I would say recently, historically, in the last couple of years when this ordinance was adopted, there was a little bit of a political compromise there. Obviously, you know, you're preserving structures that are already recognized to be historically significant per that listing, but, you know, not, you know, it was a sort of acknowledgement. We're not going to grab every single structure that could be, you know, historically significant, or for better or worse, give the commission or any other city board the ability to add that without the property owner's agreement. Just, it was sort of a compromise between trying to grab the entire, you know, National Register district, which is, you know, thousands of structures.
Right. So the nice thing about demo delay, as opposed to the DCOD and the DOD, which, you know, Joe sort of mentioned this. Joe might not realize that under demolition delay, the building does not have to be listed. It has to be a certain age. That's the only criteria.
Right.
So, I agree, it's convoluted, it's confusing, but under demo delay, it does not have to be listed. It just has to be a certain age. So
Yeah.
that's a difference in demo delay. And I can think, and I'll send you an update, because I had some ideas earlier about the buildings that should have they are listed already but have no Form Bs. Certainly the Brown School, the courthouse. I can't find a Form B for the courthouse on the
At the mall.
Nope, couldn't
Wow.
find it. I actually just recently looked for it and I couldn't find it. The William Lloyd Garrison House, it does have a Form B, but it's very poor. So that house really needs to be researched better to pin down its built date. So it's kind of all over the place. Like, it's between 1750 and 1800.
Yeah.
I mean, that's an important building. Something's happening to it now. It's already listed, so we can just update the Form B.
Yeah. I want to, sorry to do this, I have to contradict one thing you said, and that when, and he just had the ordinance up there, we can, even if a building is less than 75 years old, you know, under number 4 there, the commission can designate it as historically significant because, you know, well, you can read, you know, the things there, but it's sort of automatic if it's 75, like it's historically significant. Then I'm talking demo delay here, right? The demo delay ordinance.
Right.
Yeah. So there is that provision,
Right.
which.
So I'm going to agree with you, Chair Richards.
Yep.
I would like Andy to agree with me. So the standards have, or the age limit has changed over the years, and it's now 50 years.
Where is in our ordinances, or
no, in the national
to be eligible?
law.
It's not right. Our ordinance doesn't trigger it, but it's eligible now with the,
I see.
Right. Yeah. So buildings 50 years are now eligible under the National Preservation Act. Probably not what it's called, but that's how I'm gonna call it.
And you did say something that confirmed a suspicion I had, and I want to confirm this with you, Andy, or maybe, you know, someone like Councilor Eigenman, that in the DCOD, when it in the definitions there of historically significant, it only mentions that it's listed as contributing. It doesn't say anything about us being able to, you know, vote it in, or any building 75 years old, or and so on.
Well,
So
it's interesting because it is a shame that the church that just went through a demo delay review is
Yep.
listed as
right.
an
Intrusive.
intrusion.
Yeah.
And so I would love for that to be included in the National Register District. I think to do that, the owners would need to agree. But under demolition delay, which is what you were hearing, that building is historically significant, and that's under demolition delay. That's a determination you can make.
Yeah. Yeah. Interesting. Well, outside this meeting, Stephanie, we may talk to you or other members of the trust since it sounds like you guys have some understanding and knowledge of some of the state and national rules as far as, getting things listed or not. And, maybe some of us, like Patricia, it sounds like you might have some understanding of that as well. I don't know, but, so.
Yeah, I'll never have the kind of time I have, at home now. And I research, sometimes I do deed research for kicks, so, and I know the deed to my house and the Form B says 1850 and then.
Yeah, mine too.
But I have the original deed. So it's easy. In some cases, it's really easy to just say, hey, here's the original deed. Let's update the district data sheet. That's free, so.
Yeah.
We'll
and have you done that, Stephanie? I mean, excuse me, Patricia, have you updated your Form B?
No, I just have all these deeds on my desktop from different, houses. When I look at Form Bs, if something comes before the commission, I look at the Form B or the district data sheet, but then I do the deed research just so I know what year it is. But now I've got all that on my desktop. So it's easy to say to the city, here's a copy of the original deed. So now we know that we can update the district. This is just stuff I have for no reason.
Yeah,
so.
And I'm in a similar position, but it's a shame that process is rather opaque, or at least it is to me. And it sounds like it is to most of us. It'd be nice if there was a simple procedure that was, posted somewhere that we could say, oh, okay, here's how you do it. You just fill out a form, or, maybe it's even an electronic form and you submit this and photographs of that, and bingo, you're done. Actually, we might be able to, remember there was one that Attorney Mead represented, it was the one on Merrimack Street that just recently, where they had updated the Form B. So obviously they know how to do it. And they, so there was that, continuation. You remember this, Patricia?
Yeah, they sent the Form B to Mass Historical, but I think in our own district data sheets, can't we just update our own city district data sheets as the Historical Commission?
I don't think so.
No,
it doesn't affect them.
Okay.
It may be more accurate, but it doesn't replace the one that's already on file.
So the nice thing is, if I may, Chairman Richard, speak again.
You may.
The nice thing is that we do have more information to update Form Bs. It does have to go through Mass Historical. It is a process. It does cost money, but less than some of the work needed for our buildings, which don't even have a Form B.
Right.
But here's, I'm going to lower my hand after raising this thought. The current district data sheets and the current what's in the Massachusetts Cultural Resources Database, which in the National Register District, some of these buildings no longer exist. So there's the SAT update that might need to be done. I'm not going to suggest that that's what you put your time into, but I just want everyone to understand that we have lost so much already, and it's never been updated. So I just, all the work you're doing to stop us from losing more is so much appreciated, and I thank you.
Thank you, Stephanie, and you're welcome. on behalf of the commission, I see that as our, as our charter or our purposes as described in the ordinances. Okay. Well, what, what did you, in bringing this up, did you have any, Andy, question for you? What were you thinking you'd like to, end up with this discussion? Any particular next action to take or anything? Or,
I mean, my suggestion would be if there's any particular leads or special interest on the commission as far as members, that maybe there's some sort of follow up there, with the Preservation Trust or any other interested stakeholders in the community to, follow up and develop the prioritization for structures that the Form B should be developed for, and listing off any consultants that would be, that we should send out the request for proposals to. And that's also reaching out to MHC to see if they have thoughts, but just to make sure that we want to have the best possible consultant for, with, stretching the dollars as much as we can. And so that way we can get it out there as soon as possible and get turnaround time and, pick up the consultant, get them under contract. And also that there's agreement over what the priority should be for the structures so that once that money is extended, we know, how many structures we can get out of it. And we haven't wasted our money.
Yep. Okay. A question for my vice chair, Patricia Picnic. Patricia, would you be willing to have an informal meeting, just, the two of us, to kind of discuss this and see if we could come up with some suggested like way of kind of a plan of attack for this? Because I know maybe, and I think I'm not alone in this, it seems a little bit kind of nebulous as to exactly how to tackle this. So, maybe we can just kind of hash through it and see if we can come up with a plan of attack as to what we should what we should try to do first, second, third, or and so forth.
Oh, I'm dying to. I mean, I keep pestering. Okay. I mean, I feel like I pester everyone about it. Like, when are we going to do that? Can we please do that? Let's do that. That's one of the things I was most interested in when I joined.
All right. So I take that as a yes.
Yeah.
Okay. All right. I'll let me look at my calendar at some time, probably maybe in the early part of it. Are you now, is it summer schedule? You teaching now or what?
I'm teaching summer school, but it's, it's just Zoom. It's just this, and it's a couple days a week. This in the next 6 months, that's the most availability I might ever have again. Okay. Well, maybe
this is a good time to hit it then.
Yes.
Okay. Well then, just for the benefit of the whole commission and as the public, what I'll do is we'll see if we can get our calendars together. But basically, Patricia and I won't make any hard decisions so much, but really it's more of trying to come up with somewhat of an action plan that we can come back to the whole commission with our proposal or suggestions to how we might attack this, and then the whole commission can, amend it, modify it, support it, whatever. Does that sound okay to folks?
Yes, I'm sure. I speak for everyone. Sounds fantastic.
Sounds good to me.
Okay, thanks, Joe. All right. Okay. We do. So why don't we close that discussion for now? We do have one other thing on our agenda that we cannot miss, and that is the approval of the minutes from July 2nd. Gretchen I think, Gretchen, if you're listening, you did a good job there was a rather lengthy discussion on the former church and so on. And so thank you for trying to capture, all of that. Is there a motion? Do I hear a motion for the approval of the minutes of that meeting? July 2? Actually, I think that's the wrong date. It's July 9th, wasn't it? Our last meeting.
It was July 9th, and I think that's what the minutes say.
Yeah. It was, yep.
Yeah.
Yeah, the minutes say that, but I'm looking at the agenda. It says approval of minutes 7-2. I'll blame
looks like
Andy or someone for it. Yeah. Okay. So was that a motion to approve those minutes from July 9, Peter?
Yes, so moved.
Okay. Is there a second?
I second that. This is Joe.
All right. Yep. Thank you, Joe. Okay. So let's do a quick roll call. Joe, as long as you're speaking, I assume, I don't want to assume.
Yes.
Anything. Okay. You're a yes. Peter?
Yes.
Okay. Patricia?
Yes.
Okay. Christopher, I don't know if we have your audio or not. Maybe we can. I see your hand went up. Okay, I'll take that as a yes. Thank you very much. Ron Ziemba, you're muted. And did we lose Malcolm? Oh, Malcolm's there. Malcolm, you're not muted. What's your vote?
I wasn't at that meeting.
Oh, okay. Then you're excluded.
I'm a yes, Glenn.
Okay,
Ron.
thanks, Ron. And I'm a yes. So with the exception of Malcolm, who missed that, that was correct. I forgot about that. Those are thereby approved. Thank you very much. Is there anything else, or I'm ready to hear a motion to adjourn if people are ready to submit that motion.
I'll move.
This is Joe. I move that we adjourn.
Okay.
Second.
Okay, thank you. All right, so motion to adjourn, Joe?
Yes.
Oh, okay, Joe, yes. Peter?
Yes.
Oh, thank you. Patricia?
Yes.
Thank you. Ron?
Yes.
Okay, thanks. Malcolm?
Yes.
Thank you. And chair is yes. Did I miss anybody? 1, 2, 3, 4, 5, 6. Who did I miss? Ron, Patrick,
Chris.
Christopher Fay. I missed him again. And there he goes. His hand went up. All right, so very good. Chris, figure out what's going on with your audio for next meeting. I know you've worked in the past, so hopefully it's just something minor. Okay, thank you all very much. And thank you, those attendees who are willing to and able and to contribute to our tonight's discussion. Appreciate it very much. And so ends the meeting of the Newburyport Historical Commission. Thank you all.
Have a good night.
Thank you. Good night.
Thank you, Glenn. Good night.
Good night.